Can you state your name for the record, please?
Larry Kazru.
Your Honor, I'm asking for a preliminary examination in this matter. I believe all discovery to be complete.
All right. You other witnesses available on 28th?
Well, Your Honor, there is one uncharged case, which I think would be a misdemeanor that's slightly related to this. So I'll work on getting that police report disclosed to defense before that date, just so they have absolutely everything. But I think as far as the four corners of this case, we do have everything disclosed. There's just one more thing I'll get over there. Right.
All right. That is my understanding. Thanks, Judge.
Preliminary examination, April 28, 2026, 9 a.m. That's before Judge Barr.
Thank you, Your Honor.
Court calls case People versus Manuel Brandhouse.
Here, Your Honor.
Stephanie Hanna on behalf of Mr. Brandhouse, who is appearing by Zoom for Barnhouse. Mr. Barnhouse, could you please state your name for the record?
Manuel Barnhouse.
Your Honor, we're just asking that this be set for a preliminary exam.
Oh,
and we also have to arraign him on the additional charge.
yes, on the additional charges, counts 4 through 7. Have you gone through that with him?
Your Honor, I have emailed him the information and we discussed it. Yes.
All right. And so as to the arraignment on counts 4 through 7?
Your Honor, my client would stand mute and ask for his next court hearing.
All right.
And we would waive the formal reading.
Defendant standing mute, or waiving formal reading, standing mute. Court will enter a not guilty plea as counts 4 through 7. One is set for preliminaries.
Yes, Your Honor.
Right. Would you be ready to go with those amended counts on the 28th?
Your Honor, it's my understanding that paperwork, yes. They've already given me what they have regarding, and I'm not anticipating any additional discovery.
Your Honor, based on the nature of the new offenses, should counsel wish to review those prior to the examination, we would need to set up a meeting with officers. That's taking place. So I don't know if that's necessarily.
So that doesn't sound like discovery is complete.
Your Honor,
Want to do that sometimes. Doesn't want to do that.
I was provided with a packet of the download from your other counsel. If additional discovery has been created, please let me know.
And based upon the offenses.
Then yes, Your Honor.
And yes, Your Honor, what?
Yes, Your Honor, we'll ask for another PCC date.
That's probably wise. All right. Probable cause conference will be adjourned to May 7th, 2026. 9 a.m. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Cannon, you really are having problems without a... No, you don't have to explain.
I did ask the other attorney if there was anything in addition to what he had provided me. He said no, but I'm getting information from Mr. So that's fine.
Who said no?
Well, Defendant Avi Leave on behalf of Mr. Larry. Mr. Larry, can you tell the judge your name, sir?
Cameron Larry.
And Your Honor, I do have a green sheet. I'd like to request an adjournment in order to just receive some additional discovery.
Any objection?
No, Your Honor, the additional discovery is new jail calls.
That's correct.
New jail calls from him to...
Last. From other pins.
Did I already revoke his privileges? So he just went around my order? Is that right, counsel?
Your Honor, based on what I've been informed by Ms. Zenda, that would appear to be the case. However, I have no direct information.
I think my mom. So you have information after I revoked his privileges that he was contacting the victim in this case, Ms. Zenda?
Yes, Your Honor.
All right, bonds are revoked. I'll grant the adjournment to the 7th of May, 9 a.m. Thank you.
Thank you.
Notice the contrast here? This section moves lightning fast compared to the previous case. Why? Because both sides appear prepared and discovery is already complete. In court, smooth and quick is usually a sign that everyone understands the assignment. No surprise evidence. No procedural chaos. Just scheduling and moving on. Honestly, after that last bond revocation drama, this probably felt like a commercial break for everybody in the room.
Court calls case People versus Ronald Bay.
Feltes for the people.
Assistant Public Defender Chelsea Vergil is with them on behalf of Ronald Bay. Please state your name.
Ronald Bay Jr.
Thank you, sir.
Your Honor, we're asking for a, sorry, preliminary exam in this case.
All right. Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 28th.
We'll try for that date, Your Honor.
All right. Preliminary examination, April 28th, 2026, 9 a.m. That's before me. Okay. Thank you.
Thank you, Your Honor.
Great day.
Let's see, Your Honor.
The court calls case People versus Terrence Smith.
Feltes for the people.
Assistant Public Defender Chelsea Vergil is with and on behalf of Terrence Smith. Please state your.
Terrence Smith. Thank you. All right. What are we doing?
Your Honor, regarding the probable cause conference, we need to ask to adjourn. I understand Mr. Smith wants a preliminary exam, but we haven't received any discovery yet.
You don't have the discovery to be able to go ahead
That's correct.
or advise. Is that coming anytime soon or do we know?
To it, and the media, I just sent this morning. Or last night, maybe when I talked to Vergil, I can't remember. The original discovery, it looks like it went over on the 10th. So I think they're trying to track that down.
Tracked it down. You want 2 weeks to do that because you got to go through it with him.
Yes, please.
All right. Probable cause conference then will be adjourned to April 30th, 2026, 9 a.m.
Have the date.
Bond continue.
Um,
Oh, go ahead.
like to address bond. Does the court,
Go ahead.
the bond violation today?
I would, but actually he's being held without bond at this point because of violation of the exclusion zone. So if you want to address it, we can address it.
Your Honor, my understanding was that he was on a GPS tether on this case as well. If that is the case, we would ask to address bond at this time.
That he was on one? Yeah,
I
he
had,
was on one.
yes, I had a bit of confusion about that because this is just an R&O, not a DV, but
This exchange is fascinating because you can actually hear credibility being tested live in court. The judge interrupts with, "That usually happens when somebody's about not to tell me the truth." Oof. That line alone tells you the court is skeptical before the explanation even begins. Then Mr. Smith personally addresses the judge, which is always risky. Sometimes it humanizes a defendant. Other times it opens the door for inconsistencies. And honestly, you can feel him trying to balance accountability with explanation. Yes, I entered the zone, but here's why. The problem is, judges rely heavily on verification. Without documentation from the GPS company or monitoring agent, the court is left deciding between evidence and somebody's word. And in criminal court, that is not a comfortable place to be.
Mrs. Feltes informed me this morning that there was a tether on this case too. I mean, I just don't want to postpone anything unnecessarily.
Well, I don't want to postpone anything unnecessarily, but there was an exclusion zone, from my understanding, that he entered.
Your Honor, he would admit to entering the exclusion zone, and I would ask to address bond.
Go ahead.
You know, my understanding, based on my conversations with Mr. Smith, I was
That usually happens when somebody's about not to tell me the truth. Go ahead, Ms. Virginia.
Your Honor, so my understanding on what occurred in this case is that he did go in the exclusion zone. He admitted that. So he was with his cousin. He's having trouble finding work. His cousin offered him work. And he got in the car with his cousin, didn't know exactly where they were going. They entered the exclusion zone. His tether went off. They immediately left the exclusion zone. And Mr. Smith then called his tether agent. That's my understanding. I don't believe he was there for any prolonged period of time. And I understand he's being held on other cases. He hopes to be released on those cases, so I am asking the court for a personal bond.
I don't have any indication as to how long he was in there.
I was there.
I also don't have an indication in this that he called his agent.
I understand those details are not in the report. I haven't been able to get in touch with him, but I'm asking the court to take Mr. Smith's word for it. I don't believe that there was any contact, which is something that is included in the report.
Well, I might do that, except that usually if like the contacts like that occur or those kinds of things, that's specifically included in the report as to how proceed to take somebody into custody.
I don't believe he was taken into custody while he was in the exclusion zone. Yes, Mr. Smith?
Can I say something?
Yep.
4/23, he was taken into custody on the 13th.
I was taken in custody at home because I called my the GPS monitor dude, and then when I asked him, I was like, my tether just went off. My cousin had came and got me to help him move. And when I called him, he's like, he can't get no ping. And he said the police are outside. He's like, yeah.
I thought you were looking for work.
Yeah, I was looking for work. My cousin had offered me some money, but I couldn't. When I got there to the zone, when he pulled up, I'm like, cuz I can't be right here. So as soon as I pulled up, I had to leave. I couldn't even get the money. But I called the community corrections and I called my GPS monitor people. I called them.
Mr. Levitt, correct?
Yes, Brian Lever, and I called the GPS monitor people and I admitted to being right there. I'll take full accountability, sir.
At this time, and until some of that can be verified, his bond is revoked because he entered the zone. I'm going to leave it at revoked at this point. If indeed get through to his GPS monitoring dude, then you can figure out from that person whether or not what he's saying, and I can get some verification of that. I'll certainly consider it.
I will work on that, Your Honor. Thank
All
you.
right. Thank you.
Yeah, all the others.
I'll work.
Court does call the case, People versus LaShawn Charles.